We're looking at, hi folks, hope you're okay, it's good to be with you. We're looking at a book by Raymond Wax, Philosophy of Law, a very short introduction, Oxford. And we're just going to read page 1, and it says, on chapter 1, Natural Law. It's just not right, it's not natural. How many times have you heard these sort of judgments invoked against particular practices or acts? What do they mean? When abortion is pronounced immoral or same-sex marriage unacceptable, what is the basis of this censure? Is there any objectively ascertainable measure of right and wrong? If so, by what means can we retrieve it? Moral questions pervade our lives. They are the stuff of political and hence legal debate. Moreover, since the establishment of the United Nations, the ethical tenor of international relations, especially in the field of human rights, is embodied in an increasing variety of international declarations and conventions, many of which draw on the unspoken assumption of natural law, that there is indeed a corpus of moral truth that if we apply our reasoning minds, we can all discover. Ethical problems have, of course, preoccupied moral philosophers since Aristotle. The revival of natural law theory may suggest that we have, over the centuries, come no closer to resolving them. The best description of natural law, according to one leading natural lawyer, is that it provides a name for the point of intersection between law and moral. Its main claim, put simply, is that what is naturally is ought to be. In his widely acclaimed book, Natural Law and Natural Rights, John Finnis asserts that when we attempt to explain what law is, we make assumptions willy-nilly about what is good. It is often a quote of John Finnis. It is often supposed that an evaluation of law as a type of social institution, if it is to be undertaken at all, must be preceded by value-free description and analysis of that institution as it exists in fact. But the development of modern jurisprudence suggests, and reflection on the methodology of any social science confirms, that a theorist cannot give a theoretical description and analysis of social facts unless he also participates in the work of understanding what is really good for human persons and what is really required by practical reasonableness. End of quote. I think there's a perception there which I agree with, that when we're talking about law and morals, the question of what is good and how we know what is good is a fundamental question which I agree with. The book goes on, this is a trenchant foundation for analysis of natural law. It progresses that when we are discerning what is good, we are using our intelligence differently from when we are determining what exists. In other words, if we are to understand the nature and impact of the natural law project, we must recognize that it yields a different logic. The Roman lawyer Cicero, drawing on Stoic philosophy, usually identified the three main components of any natural law philosophy. Quote, the law is agreement with nature, it is of universal application, unchanging and everlasting. It is a sin to try to alter this law, nor is it allowable to attempt to repeal any part of it, and it is impossible to abolish it entirely. God is the author of this law, its promulgator, and its enforcing judge. The book by Raymond Wax goes on, and then I'm going to start to just give my own thoughts. This underlines natural law's universality and immutability. Its standing as a higher law and its discoverability by reason, it is in the sense natural. Classical natural law doctrine has been employed to justify both revolution and reaction. During the 6th century BC, the Greeks described human laws as owing their importance to the power of fate that can. This conservative view is easily deployed to justify even iniquitous aspects of the status quo. By the 5th century BC, however, it was acknowledged that there might be a conflict between the law of nature and the law of man. Aristotle devoted less attention to natural law than to the distinction between natural and conventional justice, but it was the Greek Stoics, as mentioned above, who were particularly attracted to the notion of natural law, where natural meant in accordance with reason. The Stoics informed the approach adopted by the Romans as expressed by Cicero, who recognized, at least in theory, that laws did not conform to reason or to be regarded as invalid. The Catholic Church gave expression of the full-blown philosophy of natural law as we understand it today. As early as the 5th century, St. Augustine asked, "What are states without justice but robber bands enlarged?" But the leading of natural law, exponent of natural law, is found in the writings of the Dominican St. Thomas Aquinas, 1225-74. His principal work, Summa Theologica, contains the most comprehensive statement of Christian doctrine on the subject. He distinguished between 4 categories of law: the eternal law, divine reason known only to God; natural law, the participation of the eternal law in rational creature, discoverable reason; divine law revealed in the scripture; and human law, supported by reason and enacting of the good, common good. He goes on, by the 17th century, in Europe, the exposition of entire branches of the law, notably public international law, purport to be founded on natural law. Hugo de Groot, 1583 and 1645, or Grotius, as he is generally called, is normally associated with the secularization of natural law. It is his influential work, Akpasisis. He asserts that even if God did not exist, natural law would have the same content. Natural law received a stamp of approval in England in the 18th century in Sir William Backbone's Commentaries on the Law of England. In recent days, Aquinas has been rediscovered by natural law theorists. Then we have Hobbes, Locke, and Rousseau. Although Hobbes in 1588-1679 remembered for his dictum that life is solitary, poor, nasty, brutish, and short, he actually said in his famous work Leviathan that this was the condition of man before the social contract, i.e. in his natural state. Natural law, he contends, teaches us the necessity of self-preservation. Law and government are required if we are to protect order and security. Under social contract, we must therefore surrender our natural fit an orderly society. Then we go on to Locke. John Locke, 1632-1704, portrays life before the social contract as anything but the nightmare described by Hobbes. Locke claims that before the social contract, life was paradise, save for one important shortcoming. In this state of nature, property was inadequately protected. For Locke, therefore, especially in 2 treatises of civil government, it was in order to rectify this law in an otherwise idyllic natural state that man forfeited under a social contract some of his freedom. Suggestive of Aquinas' fundamental postulates, Locke's theory rests on an account of man's rights and obligations under God. The fall and rise of natural law. The waning influence of natural law theory, especially in the 19th century, resulted from the emergence of 2 formidable foes. First, as we shall see in the next, associated with legal positivism, constituted resilient opposition to natural law thinking. Secondly, the idea that in moral reasoning there can be no rational solutions, so-called non-cognitivism in ethics. David Hume, 1711-76, in his Treatise of Human Nature, first observed that morally seek to derive an ought from an is, we cannot conclude that the law should assume a particular form merely because a certain state of affairs exists in nature. Thus, the flowing syllogism, according to his argument, is invalid. All animals procreate, major premise. Human beings are animals, minor premise. Therefore, humans ought to procreate. Conclusion. Hume sought to show that facts about the world or human nature cannot be used to determine what ought to be done or not done. Some contemporary natural lawyers, while admitting that the above syllogism is indeed false, deny the classical natural law attempt to derive an ought from an is in the manner as we shall see below. Then we have the The American jurist Lon L. Fuller's 1907-78 famously developed a secular natural law approach that regards law as having an inner morality. By this he means that a legal symptom has the specific purpose of subjecting human conduct to the governance of rules. Fuller recounts the moral law tale of fictional King Rex and the 8 ways in which he fails to make law. Ill-fated King Rex bites the dust because he disregarded Fuller's 8 principles, which are generality, promulgation, non-retroactivity, clarity, non-contradiction, possibility of compliance, constancy, congruence between declared rule and social action. Contemporary natural law theory, John Finnis. The Aquinas tenets of natural law have been revived and meticulously explored by the legal theorist John Finnis, most assuredly and comprehensively in his book Natural Law and Natural Rights. It is important to grasp the purpose of Finnis' enterprise. He rejects David Hume's conception of practical reason, which maintains that my reason for understanding an object is merely an ancillary to my desire to attain certain objectives. Reason informs me only how best to achieve my desire. It cannot tell me what ought to desire. Finnis prefers then as Aristotelian foundation what constitutes as worthwhile, valuable, desirable life, and his menu contains what he calls the 7 basic forms of human flourishing: life, knowledge, play, aesthetic experience, sociability, practical reasonableness, religion, etc. And it's quite in depth on. Then you have positivism, which developed by H.L. Hart. The term positivism derives from the Latin positum, which refers to the law as it's laid down or posited. Broadly speaking, the core of legal positivism is the view that the validity of any law can be traced to an objectively verifiable source. But put simply, legal positivism, like scientific positivism, rejects the view held by natural lawyers that law exists independently from human enactment. As will become clear in the chapter, the early legal positivists of Bentham and Austin found the origin of law in the command of a sovereign. H.L. Hart looks to a rule of recognition that distinguishes law from other social rules. Hans Kellerson identifies a basic norm that validates the concept. Legal positivists also claim that there is no necessary connection between law and morals, and that the analysis of legal concept is worth pursuing and distinct from, though not hostile to, sociological and historical inquiries. Hart says, the certification of something as legally valid is not conclusive of the question of obedience, however great the aura of magisterial authority which the official system may have. Its demand must be submitted to a moral scrutiny. And then we could look at Bentham. H.L.A. Hart, 1907 to 92, is often credited with charting the precincts of modern legal theory by applying the techniques of analytical and especially linguistic philosophy of his work. And there are many other scholars, such as Hans Kelsen, attempted ethical cleansing of legal theory. Hans Kelsen, 1881 to 1973, in his complex pure theory of law, expounds a subtle and profound account of the way in which we should understand law. We should do so, he insists, by conceiving it to be a system of oughts or norms. Kelsen does concede that the law consists also of legal acts as determined by these norms. Then you have Joseph Ratz, Law as Social. You have Ronald Dworkin, regards law as an interpretive process under which individual rights are paramount. You have John Rawls' theory. A Theory of Justice by John Rawls in 1921 to 2002 is widely regarded as a tour de force. It expounds the concept of justice as fairness and has justly become the focal point for contemporary discussions of the subject. The idea of justice as fairness may at first blush strike you as trite. Both in dismissing utilitarianism as a means of determining justice, Rawls rejects the very idea of inequality, even if it secures maximum welfare. Welfare, he argues, is not about benefits, primary social goods, which include self-respect. In particular, he contends that questions of justice are prior to questions of happiness. In other words, it is only when we regard a as just that we can judge whether it has any value. How can we know whether the gratification Tom desires from torture should be counted as having any value before we know whether the practice of torture is just itself? So those are just some theories of law and how people come to conclusions there. I think a couple of things that I get from reading that book, and I've really enjoyed reading it, and I've got to read it again on some parts, is some of the early theories, like Hobbes, were very cynical of human nature and felt that law was there to restrain sin. The other thing that I find interesting is the early ones seem to have a general idea that there are general laws to be discovered, apart not David Hume, but people like Locke and Hobbes, which goes back to Cicero. And I think that, I think that if you believe in evolution, if you believe in the historical flow as an evolutionary process, then your idea of what law should be is a social construction of the particular period of time that you're in. So it means that you can't really talk about value, you can't really talk about good, because good and value are relative to the particular time of the historical flow that you're in. I think what happens is we make laws and we use words like value or good, but we are building on the capital of some kind of natural law. That is to say that there are some general ideas and general thoughts about what law should be from generation to generation. There might be changes within the law, there might be changes in time, but within those changes there have been certain principles, and the principles are that human beings have felt that they should be just. However they've worked that justice out, it's been a general thought. So when you look at ancient cultures like Egyptian culture, for example, there was a sense of need for justice, justice in marriage, justice in relationships. Now, they might have applied it in a different way. They might have come up with strange ideas, but there was a general idea that governed what they were trying to apply that law. So what I'm trying to say is that within culture, every culture in every age, I think that there has been, even in the most tribal societies, an instinct for certain things that they might work it out in a way that we would not agree with, but there's certain instincts for justice within society. Now, they might get it wrong, they might completely be, what we think is just might be completely different to what they thought was just, but what I'm saying is there's been these general instincts, which shows you that, I think, points to something greater, that without the eternal God, without eternal concepts of what is good, then we're always going to be in a relative position. And I think that's the key. I think you can have eternal principles, but how they're applied in each age, that's the only way that I think you can get out of the problem of being relativistic in your understanding of law. Because, like I said, no matter how much you claim to have universal values, ultimately your own system deconstructs itself because you're in a historical flow of a particular time, and in a particular time, it's only going to be a social construct of that time, of that culture, of that age. But the reason why things work sometimes is because there are universal laws that even in a particular time and a particular culture and with a particular social construct, the universal laws kick in underneath it. I think if you read C.S. Lewis' Mere Christianity, he unpacked more on this issue. So what am I trying to say? I think basically there has to be universal values, and you need the Bible, and this is the point. You need the Bible to give you the eternal value, the eternal understanding of what is good, what is valuable, what is right, and what is wrong. You need these eternal truths, and they will comport to our conscience and who we are as human beings. They will resonate with us. And on that basis, we can build social justice and laws. However, you know, when you look at the Magna Carta, which was influenced by the Bible, it comes down to that every human being is valuable before the sight of God. Without that concept, there would have been a republic. Without that concept, there would be no democracy. And that concept is a foundational concept within the Christian faith and is the basis of making laws, I think. Anyhow, these are my ideas. What I find very interesting, and I'll have to go now, is how Sir Thomas Aquinas has had a big impact on the philosophy of law. If you look at these various theories, even today in the philosophy of law, they've been massively impacted by Sir Thomas Aquinas. I find that very interesting. Anyhow, I've got to go. Just a little soiree on the philosophy of law. We'll be doing other topics and preaching and discussions. So enjoy. Don't forget to listen to my lecture on democracy, public space, and preaching, which was given quite a few years ago, and a lot of the political issues that we're seeing in France and around the world today, I already showed in that lecture. I think today things have changed. I think that the situation politically has changed now, and we need a different strategy. But my lecture would have been helpful if people would have taken it more seriously. All right, I got to go, and take care, and God bless you.